Excellent. All right, well, I'm going to begin right now. It's now still 6 o'clock. So good evening, everyone at 6 p.m. and welcome to the special early session to the Newburyport Zoning Board of Appeals meeting for November 9th, 2021 via Zoom. My name's Mark Moore, Vice Chair, calling this meeting to order as our Chair, Rob Ciampetti, can't be here tonight. But fear not, our exhaustive nationwide manhunt has made significant progress, and we're confident that our chairman will be assuming the electronic gavel in the very near future. As always, we have our City Planning Director, Andy Port, and City Planner, Caitlin Sullivan, handling presentations and audience participation. And before we start, we always recognize Gretchen Joy for her great work and dedicated efforts. I will start tonight with a roll call introduction of the board to verify that we have proper quorum. As I mentioned earlier, I'm Mark Moore, Vice Chair, obviously here. Rob Ciampetti, our chair, is absent, and the board has been made aware that Associate Member Greg Bennett will also be absent tonight. With that said, I will now introduce each member in attendance, and I ask that each please respond with here or present. Secretary Stephen Delisle.
Here.
Thank you. Member Ken Swanton.
I'm here.
And member Walter Budchak.
Here.
Excellent. Finding 4 members present, we have legal quorum and can proceed with the meeting with all members voting. Because we have a minimum board tonight and 4 votes needed to support an application required for approval, unanimous support of the board will be necessary. I'll be reminding everyone of that when we start the public hearings at 7 p.m. Tonight, before we begin the public hearings at the customary 7 o'clock, we have 4 applicants that also have requested to continue. Our early special session was requested by the board to conduct a discussion and overview of the 40B permitting process, as well as to vote on certificate of vote for electronic signature use in our decisions. These subjects will be addressed in a manner that the usual 7 o'clock starting time for public hearings will be honored. I will refrain from my usual wonderfully read preamble until that time, until 7 o'clock, that is. And we will now dive into our second item on the agenda, the 40B permitting process. I think Andy Port's going to do a little bit of an introduction first.
Thank you, Chair Moore. Just a brief word of introduction for Attorney Whidden. We're happy to have him from KP Law. KP Law is the city's legal counsel, and Attorney Whidden specializes in the area of 40B. As some of you know, or all of you know, there was some recent discussion of a potential 40B mentioned by New England Development and Avalon. Irrespective of whether that application is brought forward or the time frame therefore, we thought it would be very important to make sure that the current board, given that I think all but maybe Rob Ciampetti, who isn't here this evening, all are new members, I think, since the last time this board had looked at a 40B. So we just wanted to make sure that all board members were generically familiar with the 40B process. Obviously, the staff here would be, shepherding through the whole process that needs to be done from an administrative perspective. But we thought it was very important for the board to have an understanding, because 40B works a little bit differently than the usual special permit variances process or appeals even that you do. It is essentially a consolidated local permit for all the other local ordinances of relief that would be needed in essence. I'm sort of paraphrasing that quite briefly for you. Attorney Whidden will elaborate, of course, but I wanted to thank Attorney Whidden for providing this overview. And then I also wanted to note that we are working on an update to the board's, Jonathan and I are working on an update to the board's regulations for 40B materials that we would present back to you at an upcoming meeting for consideration and presumably adoption. That's to make sure that the board and the city are in the best possible position, regardless of what 40B may or may not be filed. One other thing I would note is that there is, in addition to tonight's overview and the slides that are provided, there is also a CPTC, or a Citizen Planner Training Collaborative session on December 21st. It's a Tuesday, I believe. And I will send around an email to the board members, but as is typical for some of the board members that have been here for a while, we'll let you know if you're interested in registering for that and attending that as well. It's typically a 2-hour session. I believe it begins at 5:30 p.m. That night. And if you're interested in attending that, that also would be sort of an overview of the 40B process and some other helpful tips and things. So I just wanted to pass it on to Attorney Whidden and thank him for joining us tonight.
Well, thank you, Andy, and good evening, members of the board. It's my pleasure to be here, so thank you for inviting me. And Andy gave a great introduction to the process, and I'll just say before I forget, What I'm going to talk to you about tonight, even at a high-level overview, is going to be very different, I suspect, than what you might hear by the Citizen Planning Training Collaborative. 40B has raised an awful lot of issues. It's a controversial statute, and we can discuss it in whatever depth the board would like. Caitlin, if you could go to the first slide, that would be great. And just by way of a very quick overview, the statute was adopted in 1969. Only one word has changed in the statute since. And so there's been no substantive changes to the statute at all. The way the Commonwealth has dealt with revisions to 40B has been by regulation and by guideline. And of course, that is an important thing to say right at the outset. The statutory scheme has not changed, but DHCD, which is the accepting agency for the comprehensive permit process, DHCD has made revisions, dramatic revisions by regulation. We'll talk more about that later. As a general rule, what the board members I'm sure have heard in the past is 40B is called often one-stop shopping, a comprehensive permit, meaning all permits are issued by the ZBA. That's partially true. The Board of Appeals does stand in the shoes of other adjudicative and regulatory bodies in Newburyport, but the Board of Appeals does not stand in the shoes of three entities. One is pursuant to the State Building Code, the other is pursuant to the Wetlands Protection Act, and the third is pursuant to Title V of the Sanitary Code, or any aspects that would otherwise be regulated by DEP or through the State Sanitary Code. With those three exceptions, the Board of Appeals does have jurisdiction to stand in the shoes of, for example, the Planning Board or the Conservation Commission pursuant to a local regulation. As a general rule, not always, but as a general rule, comprehensive permits filed pursuant to Chapter 40B will be at a density greater than what the local regulations would support. That's not always the case. So next slide, Caitlin, please.
Like I'm having trouble pulling up the PowerPoint. If you want to give me a minute, or perhaps Andy, you
Sure.
have it handy.
Yeah, that's okay, Caitlin. Not a problem. You could even go to the next slide, Caitlin. I can describe what's on that third slide.
Looks like I'm having trouble having the slide show at this moment. Perhaps there we go. Andy has it.
Okay, that's fine. Andy, if you can go back one. Great. Okay, so the statutory scheme is Chapter 40B, sections 20 through 23. The regulations, which really are the most important thing for the board to focus on if you get an application, is 760 CMR 56. It's a fairly long regulatory section, and it is decidedly anti-municipal, and that actually is an objective statement. It is not supportive of what the city might want to do or how the city reviews traditional proposals. It is drafted by DHCD, it's adopted by DHCD, and of course their mission is to create additional housing. So having kind of that at least open mind when and if the board does get an application is important, because the regulations are inconsistent with the statute. And as we all know, the supremacy clause requires it to be the other way around. The statute trumps the regulations. So the board is likely to encounter several frustrating incidents where the statute says one thing and the regs contradict that. And I'm going to talk about the most important ones in just a few minutes. You can see on the bottom bullet there, chief among them are the issues of safe harbor and what is meant by consistent with local needs. So next slide, please, Andy. Andy had mentioned that Andy and I are discussing your local rules and regs, which are very good. They need to be updated in many respects. And in my opinion, they can be much more aggressive. But of course, that is a decision only the Board of Appeals gets to make. The regulations are good as they stand. I think you might want to consider other opportunities to tighten them up a little bit. One of the most important things about a comprehensive permit, especially in the city, and especially in a city such as Newburyport, which has done a lot of planning over the years, is that the regulations can reflect, your regulations can reflect your goals, what the city wants in terms of below market rate housing, whether it's for sale or rental or a combination of both, whether it's scattered site or larger projects. The regulations can embody that because the regulations really become part of the plan that the city has adopted all these years. The regulations cannot be independently appealed. And that's an important point as we go a little further on this evening. So the Board of Appeals would adopt regulations, hold a public hearing, adopt the regulations, file them with the city clerk. They become effective upon vote. And those regulations cannot be appealed by a developer independent of the developer's application. So burden initially on the developer to comply with the regs. And then if they're unhappy with the regs or your decision, they can appeal that, of course, but they cannot independently appeal the regulations. So that's an important thing just to kind of park away. Next slide, please, Andy. So the entire statutory scheme revolves around two phrases. Consistent with local needs, that's where we are right now. And then in a minute, we'll talk about uneconomic. Consistent with local needs means that the city has achieved either what the statute says or the regulations say are your fair share of affordable housing. It is a complicated formula in some respects. In other respects, it's very straightforward. Consistent with local needs is the phrase found in the statute. The regulations use that phrase, but also adopt a new phrase called safe harbor. So it's entirely possible the board will hear either or both. They're synonyms, they mean the same thing. If the city is consistent with local needs, it removes jurisdiction from the Housing Appeals Committee on an appeal of your decision. Meaning the Board of Appeals can approve my decision with conditions, or approve my application rather with conditions, deny my application for any reason at all, and I am stripped of an appeal to the Housing Appeals Committee. So it deprives the Housing Appeals Committee of subject matter jurisdiction. Very, very important. It's the carrot that the legislature held out in 1969 for cities and towns to be able to say no to an unfriendly, non-consistent with plan project. So of course, cities and towns want to get there. It's exceedingly difficult to get there unless the city has a demonstrable case that it meets either one of the three statutory means of defining consistent with local needs or one of the four regulatory means. So there's 7 in total. I'm happy to discuss this in greater detail, but one of the most relevant ones for a city such as Newburyport would be, in my opinion, the 1.5% of the city's land area containing below market rate housing and or compliance with the housing production plan, meaning the city has an approved plan and then is building below market rate housing in accordance with that plan. You may have heard the most commonly referred to safe harbor is having 10% of your housing stock below market. You either have it or you don't. That determination is made by DHCD. It's relatively irrebuttable, so cities and towns know kind of a bright line whether you have it or not. I should add, because this comes up a lot, the definition of what makes it on the subsidized housing inventory, which is the volume of below market rate housing as inventoried by the Commonwealth. What makes it on there are not units that are necessarily affordable, but units that are tied to a subsidy and otherwise meet the criteria of DHCD. I represent many cities and towns that have mobile home parks, completely affordable, but none of them count. I represent many communities with a lot of affordable housing, very blue collar communities, a lot of affordable housing before the latest boom. None of them count. So in order to get them counted, there's a process that the city has to go through. Andy's familiar with it. You get units added to your subsidized housing inventory, But one of the misnomers out there that I suspect the board is going to encounter if you get an application is the public or other members of the city commenting that we have affordable housing. The answer is yes, but it may not count. And Mr. Chair, I should have said at the beginning, please feel free to interrupt me to the board members as we go through. By all means, do not hesitate to do that.
Thank you. Excellent.
Andy, I think next slide, please. The consistent with local needs status is really the holy grail of 40B. Because if you're consistent with local needs, the bottom bullet may be the most important. You can still say yes. And in fact, many cities, Cambridge is probably the best example. I just helped the town of Amherst with a 40B. They've been well over 10% for decades. If you're consistent with local needs, you can still say yes, but you can say yes with impunity because the applicant has no appeal to the Housing Appeals Committee. So you can impose conditions, you can negotiate on density and virtually every aspect of the project. If you're not consistent with local needs, there's a presumption that you're not consistent with local needs. And if you're not, we move to the next category, which is the board's ability to contour the project is dramatically limited. And it's dramatically limited by the next word, which is uneconomic. So Andy, I think the next slide, please. Uneconomic is what the statutory scheme calls leaving a project in a situation that the applicant cannot earn the income, the profit that he or she or it was otherwise entitled to based on the subsidizing agency's decision. The numbers, of course, are different if they're rental or if they're sale, but suffice to say there is a formula that defines what economic means. This just requires a couple more minutes of conversation though. An applicant will file for a large project, and if the board concludes it's too large or we need additional protections for groundwater or surface water contamination, or we need better ingress or egress because the fire chief says you need two ways in and 2 ways out, what the applicant will say is, we cannot pay for those conditions without the project becoming uneconomic. And what that means is we will not make the sufficient profit that we're entitled to. And with all due respect to the development community, developers make up the numbers routinely. Developers come in high, they expect to be negotiated down. So it becomes an important moment for the board to make sure that their claims, the applicant's claims of uneconomic, are true and vetted by an expert that the board retains. Because the entire matter turns on this one word, if the city is not consistent with local needs. So uneconomic really becomes a key important process. The Housing Appeals Committee figured this out a long time ago and has moved the goalpost repeatedly. A case that I've had out of Stoneham for years, the project, when applied for, was uneconomic. The developer applied for an uneconomic project, 249 units. It's a large rental project. They now claim on appeal, and it's in Superior Court, that the board imposed further conditions making it more uneconomic. But if a project is already uneconomic, how does one make it more uneconomic? Because the statute simply says uneconomic. So it's an important statutory protection for cities and towns, but the regulations in the Housing Appeals Committee have really, really tortured what the legislature meant in 1969. And the reason I raise it again is because if you're not consistent with local needs, this is going to be a really important deliberative part of the board's review of the project. Next slide, Andy, please.
Before we do that, Attorney Witten, can I ask a question? Who is the expert on the uneconomic question? And I'm sure it varies. Who would be the experts that would be suggested in order to determine how truthful the numbers are, either pro forma or whatever?
So what I've done, Mr. Chairman, is recommended, instead of a consultant or instead of kind of the corral of folks that typically get involved, is for the city to hire a CPA. And the best CPAs in my experience are forensic accountants who have the ability to really look at the numbers and do some vetting as to their accuracy. In conjunction with a professional engineer, if that is part of the issue, and it usually is. Between the PE and the CPA, you will get an honest assessment of the numbers. That is usually the way to do it. The development community, I'm generalizing, of course, but most developers don't hire a CPA to come to the Board of Appeals. They'll hire a consultant, and they'll pick a lot of numbers, and it's a pretty unprofessional process in many respects.
Right.
That doesn't mean you won't get a professional application, but you really want to counter that, I think, with professional advice as to the accuracy of the numbers, because the numbers are everything.
Right.
Attorney Whitten,
Please.
sorry, if you could just clarify for the board as well. I know you and I have talked about this particular issue and the need potentially for that during permitting should it come up. The expectation here, I think, is that this is typical of peer reviews where the applicant is essentially paying for the cost of this. However, the consultant is reporting directly to the board in their peer review capacity.
Yeah, absolutely, Andy. And I was going to get to that later on, but let's talk about it now because it's a good time. So, and again, I apologize to the board members if I'm saying what you have lived with for years and are comfortable with. But 40B does not exclude at all the board's opportunity and ability to use Chapter 44, Section 53G, which is really what Andy is getting at. So if I'm the applicant and I file a comprehensive permit, you have the right to require me to pay for your list of consultants that you need to review the project. And that money goes into a city escrow account. Any excess money gets returned back to me. The city treasurer has an obligation to do that. And the board has no limit as to the expertise that you might need. So I have had cities and towns use it to hire a stenographer for the opening and all of the hearings. So you have a stenographic record. Landscape architect, hydrologist, hydrogeologist, CPA, and so on. So there's no limit, and it's going to depend on the project that you get. The only limitation on 53G money is a decision from the Housing Appeals Committee, which in my opinion is completely ultra vires. They don't have the authority to say this. The HAC said you cannot use legal services. You cannot force the applicant to pay for legal services. That contradicts 53G, supremacy clause, but no community has yet challenged that. And if they did, I'm confident they'd prevail because once again, the Housing Appeals Committee, which has lost many cases in the appellate courts because of their overreach, the Housing Appeals Committee would lose that one as well. But that may not be a fight you want to take on. Every other discipline is within your purview.
Mr. Whitten, does this ability to hire professionals, does this go to the issue of whether the project is uneconomic?
That's
I mean,
great.
can you create a situation where you can kind of move the project into an uneconomic status, either wittingly or unwittingly through yeah, go ahead, sorry.
No,
I
I spoke over you. That's an excellent question. That is exactly right. And one way to think about it is the developer, the applicant, has an adding machine, kind of an old school adding machine. Everything you tell me you want, I'm just typing into that adding machine. And what I'm going to say is, when I tally it all up, that's $100,000 worth of things, including 53G. That makes the project uneconomic. So yes, it is possible that an applicant would do that. But let me say this, if Newburyport gets a 40B application that is uneconomic because of a $50,000 or $75,000 53G requirement, that project never had legs to begin with. So, but your point is well taken, and that is exactly the way to think about it. Uneconomic is, can I push, can I push, can I push? At some point you've pushed too far. But notice, and I know you're thinking this, where is the line of how far you can push? How much off-site improvements can we require? How much scaling back of density? How much more architectural design can we require? You only can know that if the developer produces a truthful pro forma. And I can tell you, in my experience, doing this for a long time, I've yet to see a truthful pro forma at the very beginning, because no good developer is going to come in at the bottom line. A developer comes in for more and hopes for the best. And that's how the process works. And in 40B world, because uneconomic is such an important piece to it, it works even more. So excellent question. That's what you want to be mindful for. How far can we push? But you need to know where the line is to push, and that has to come from the developer, and that has to be vetted by your experts. The next part of the conversation, but again, if I'm going too fast, just stop me. The next part of the application is how this whole thing starts. And it starts with what's called a project eligibility letter, sometimes called a PE letter. It typically, I'd say 75% of the time, comes from Mass Housing. Mass Housing is an authority, much like Massport, an independent but not really independent arm of the Commonwealth. They are in collaboration, of course, with DHCD. They issue PE letters. They are rarely denied. And I can already tell you what the PE letter will say, because they say the same thing whether you're in Newburyport or in Belchertown. They all say the same thing. So let's assume that an applicant makes an application for a project eligibility letter. That will be approved. Before it's approved, though, the city will have a chance to comment on that application. In my experience, those comments will be respectfully received and then ignored. I've had senators and state reps join in on those comments, respectfully received and ignored. So I think we should assume that the project eligibility letter, if one is forthcoming, is going to be approved. Once it is issued, the developer has 2 years to file for a comprehensive permit. But in reality, Mass Housing indefinitely approves extensions. So once it's issued, it's irrebuttable, and it's going to last for a long time. Andy, next slide, please. Now I have a project eligibility letter, and now I can make an application to the Board of Appeals. So in order to meet with the board, in order to formally file with the board, I need that PE letter in hand, and then I file. And here's where your regulations really come into play. What do I have to file? Now, it can be something very kind of straightforward, procedural, like number of copies of plans, whether it's on a CD, whether it's electronic, but it can also be very substantive. Architectural renderings, landscape plans, details that if you don't require, you will not get. Because the Housing Appeals Committee regulations, 760 CMR 56, require bare bones, very preliminary plans, and that's what the regulations say, preliminary plans. If the board wants detailed, you're going to have to require it. And the best place to require it is in your regs, because those are not independently appealable. Now, one of the most dramatic ways that the regs and the statute are in conflict, or the regs are in conflict with the statute, is the statute says that the board must open the hearing within 30 days of the application. That's the first bullet. But then the regs say you must close the public hearing within 180 days of its opening. Now, the statute says you must close the public hearing when you decide to close the public hearing. Now you're under pressure to close within 6 months. Once the board closes, you have to record your decision with the city clerk within 40 days. So 30 days to open, 180 days to take testimony and evidence, and then 40 days to render and file your decision. Now, of course, all of these dates, except for the 30 days, can be extended by agreement with the developer. Do not, under any circumstances, in my opinion, respectfully, extend the 30 days, because it's jurisdictional. The developer can grant an extension on the 180. The developer perhaps could grant an extension on the 40, but in my opinion, the developer does not have the authority to grant an extension on the 30 because it's jurisdictional. Next slide, Andy, please.
Yeah, sorry, Attorney Whitten, if I could just interject. One thing to keep in mind, we in the office, Caitlin routes plans and materials that come in to the other departments for reviews. That goes along with obviously the typical sort of internal peer reviews that we do for the various boards to try to provide input from the various city divisions on any concerns that might be relevant. We provide obviously all that to the boards. In this case, we would do the same for the comprehensive permit. So you'd have the benefit of those things. We would obviously let those departments know, there's a sensitive time frame for turning around those issues and any concerns. And obviously that goes hand in hand with any sort of peer review that might be needed from, say, a CPA or others.
Yeah, good, Andy. Thank you. That's great. So now we're still in the timeline, and here's the part that is really worth stressing loudly. The regulations also tortured cities and towns by requiring you, the board, to make a decision on whether the city is consistent with local needs, safe harbor, within 15 days of the opening of the public hearing. Now that respectfully is crazy. You've got professional staff, smaller cities and towns do not. Without professional staff, it's impossible, if you're not prepared, to determine the complexity of the 1.5% calc, for example, in 15 days. So one of the things Andy and I have talked about is to do this work ahead of time before you even know that there's a project eligibility application in the pipeline. The 15 days are 15 days from the opening of the public hearing. And remember, you only had 30 days within which to open the hearing. So within those 15 days of the opening, the board must assert safe harbor or you've lost it forever for this project. My advice to cities and towns is if you have a good faith basis for asserting safe harbor, assert it. Because if you don't, you're going to lose it. So if you're close, if Andy comes back and says, we're close, not perfect, but we're close, that's good enough for me. If Andy comes back and says, we're so far away, forget it, well, then that wouldn't be in good faith. But if you're close, you're close. If you don't assert it, you lose it. And because safe harbor is so important to the outcome for the city, it's really something for the board to think about. And it's only the ZBA's decision. Nobody else can tell you what to do here. I should also add that safe harbor is good per project. So if you assert it for project A, you'd have to assert it again for project B. So you have to do it each and every time. If you don't assert, then the city is going to be deemed not consistent with local needs. Now, if the board asserts safe harbor, then the applicant can appeal your decision to DHCD. DHCD inevitably overturns the city, and then the city can appeal that overturning to the Housing Appeals Committee for an interlocutory review and hearing. Typically takes about a year, sometimes a year and a half, lately even longer. If that happens, which it always does if the city asserts, the case in chief is frozen. The board is not continuing the public hearing. That process is stayed automatically until the Housing Appeals Committee decision comes out. If the city prevails, the city is consistent with local needs. If the city loses, the case comes back and you start all over again right where you left off within that 15-day period. Let me just stop there for a second and just, does that make sense, board members? Are you comfortable with that, or would you like me to talk further on
I
this?
have a question. I'd like to ask a question on this, Ken Swanton. What I hear you saying is if somebody presents an application to us, we have 15 days to decide whether it's safe harbor. That's a decision, or to claim whether we are, a safe harbor status, which is something only the Zoning Board of Appeals can decide, is what I hear you saying. So it sounds, is what you're saying that if we are concerned that one may be coming, that we should be poised and ready to...
Yes, sir.
Is that basically what you're saying? Because I don't feel poised and ready right here. I mean, how do we get poised and ready so that we can decide, so if one comes over the transom tomorrow, we can do it within 15 days.
Yeah, great question. And that is what I'm saying. So here's the good news. The good news is you'll always have no less than 30 to 60 to 90 days before one comes over the transom. And the reason for that is an applicant who seeks a project eligibility letter must notify the city council and the mayor first. they will have 30 days to comment on that application. And they can always ask for at least one extension. Mass Housing will always grant one extension. So that gives us, let's say 30 plus 30, 60 days before Mass Housing could possibly issue the project eligibility letter. So that is the window, worst case, where the city could scramble to get that information. But because we're so ahead of the curve, the city could be preparing the 1.5% calculation whenever the city has time to do that. So yes, you can get prepared so that the city knows and the board knows how close, how good the numbers are. And that is something that Andy and I've discussed. It's definitely worth the effort.
Can I ask a follow-up question?
Please, please.
Which is, so I'm glad to hear that there's typically more like 60 days warning before we have to, come up with before the fuse is lit on the 15 days. But since it's our decision at the end of the day, I'm a little confused. Who do we task right now? Or, they don't work for us. They're employees of the city. Or, do we go to the mayor and plead with them to please get somebody in position quickly? Or,
Well,
I'm just, yeah.
Ken, this is Andy. Maybe I could answer your question. The city staff are actually already looking at that issue in the Office of Planning and Development. So we are doing the analysis, the 1.5% area analysis that Attorney Whitten had mentioned to provide any information that might be beneficial to the board in that effort. And the same thing with the subsidized housing inventory itself, whether or not we're at 10% or making progress, which is the certification of the housing production plan, those different avenues. We are essentially tasked with providing you that information. So we are looking at the mapping end of it as well to do that analysis right now. That it takes a little bit of work, as Attorney Whitten knows, because of the way that the statute and the regulations work and the way it parses down areas. But we are doing that right now, recognizing that we have a little bit of time to do that. We are doing that now for that very purpose, to address your concern.
Okay, thank you.
So Andy, the goal would be that when the letter is sought and the city is made aware, then in some kind of staff report, the board is made aware that, hey, there's something in the works. Here's our current numbers.
Yeah, that's correct. As long as we're not in any way sort of undermining this position, we will be conveying any information that's helpful to you, and certainly a heads up where we get notification of a project eligibility request and so forth formally. So we'll certainly be apprising you, whether that's Caitlin or I. We'll be providing that in a staff report or other update to the board, and obviously assisting you should there actually be an application that reaches you as a comprehensive permit.
Okay.
And there's a fair bit of...
I'm sorry, may I ask one further question of Andy?
Please.
Andy, just curious to know, how far along in this process are you and the planning office in analyzing or preparing the three sort of avenues that I think you mentioned?
Well, to be clear, we're not at 10%. So that one is not, in my likely sort of, is not a reasonable possibility at this point, based on our existing subsidized housing inventory. And obviously we weren't intending to go into an in-depth discussion about those tonight, but that's not one threshold I think that would be relevant here. And again, Attorney Whitten can weigh in on that. But just based on where we are and the likelihood of being able to get to the 10%, in the time frame before a permit, let's say if it were coming, spring of next year, it's not clear that we would be able to do that. The area calculation, we are doing that using our GIS, or Geographic Information System. So we're in the middle of that right now. Again, because of our subsidized housing inventory and the way that the calculations essentially have to be done, although I don't think we're parsing that out in sort of boring you with the details of that, because that has to be parsed down a little bit, and then Attorney Whitten and I might have to have further exchanges on that to make sure we're in a clear about how we're presenting numbers there. That may require a little further back and forth as to how each unit or portion of that inventory gets calculated. So we're, I would say sort of 25% into that right now. So again, we fully expect to be closing that loop and to be able to provide any information that may be helpful to you prior to the application, coming to you and prior to that 15-day window. But we have not made it, 75% of the way through that, because the parcel level analysis that has to be done in some of these instances takes a bit of work. So we're in the middle of that. Attorney Whidden and I have already spoken about that, and we're doing the background work, but we still need a few more weeks to finish that analysis so that we can provide some numbers to you on that threshold. On the housing production plan certification, which is another threshold that I think is key here, in summary, while we are not at 10%, there is on the horizon a 40R project, a different statute, smart growth, a 40R project that has been proposed in the city. And again, I'm boiling this down here, a summary of a worksheet that Caitlin and I put together. But in essence, that project that is currently before the planning board has over 80 units in it. And because it is over 80 units or would include 80 units, that project could, upon approval, provide the city with a safe harbor status. Now, there's little caveats and things like that I'm sure Attorney Wood and I, we could, so to speak, elaborate on. But in essence, that project would be one path to certification of the plan production, the housing production plan that we have that's been approved by the state, but not, quote, certified, meaning we've made progress. So on that approval of the 40R project, that would be a potential instance in which one of those three boxes is checked. So that's in addition to the 1.5% area analysis we're doing right now. I don't know if that answers your question or if there's anything else that I can elaborate on.
No, thank you. That does answer my question. That's very, very concisely. I appreciate it.
Attorney Whitten, I had a question that came up in the previous Board of Appeals I served on. We were in a town where we went in and out of safe harbor multiple times while I was on the board. And when you claim safe harbor and it goes back into to Boston and we have this, say, a 1-year delay before a decision comes out, whether the safe harbor is valid or not. If it's proven not to be valid, the 40B comes back to the Board of Appeals and we start again, is my understanding. You could go into safe harbor during that 1 year, 1.5 year delay.
Right.
Does not the clock reset and or does it go back in time?
Yeah, great question. And no, so the magic moment is when the applicant files with the city clerk. So once an application is made, it is safe. It really creates vested rights almost. And to answer your question just more dramatically, I still have a case out of Middleborough from the year 2000. And it is working under the rules and regs in play for the year 2000. Yeah, no, great question. And cities and towns do that. They come in and out of safe harbor, new applications are filed, but the applicant always claims and is always protected by the original filing date, regardless of the litigation that will follow. Great question. Yeah.
Okay, thank you.
Sure.
But if I could before we go, just
Please.
we're 45 minutes in with the public hearing starting at 7. So I would respectfully ask, we don't want to just gloss over this, but just if we could all cooperate, just to maybe get the last 10 slides in before we run out of time.
Absolutely. Let's go to the next slide, Andy, please. And I will keep that in first and foremost in mind, Mr.
Thank you.
Johnson. I can move very quickly. Andy, it's the slide that says waivers to local bylaws and regulations. So one of the things I want to make sure I say to the board is all of your rules and regulations can be waived. But the question is, why would the Board of Appeals waive what the City Council adopted as zoning or waive what the Planning Board adopted as rules and regs for subdivision or stormwater disposal? And the answer is you would only waive it if, but for the waiver, the project would be uneconomic. Otherwise, we really have kind of lost the democratic process here. If an applicant can ask for a waiver just because I can ask for a waiver without any rational basis for the waiver, then that's kind of anarchy. So the way to ensure that the waivers are needed is to hinge it, to link it to the phrase uneconomic. Some waivers will be needed to keep the project from being uneconomic. Probably multifamily in a single family district, probably density in terms of minimum lot size. But other things that might be burdensome, no, respectfully, the board has the right to hold on to what your legislature has adopted. So much more to say on that, but I just want to make sure I got that in there. Andy, if you could go to the next slide. If the board issues a decision, if you're not at safe harbor, and you issue a decision that does not render the project uneconomic and is intended to protect health and safety of the residents and the city at large, that decision should be upheld. In reality, it won't be. You'll lose at the Housing Appeals Committee because the Housing Appeals Committee has routinely, I can count on two hands the number of times the Housing Appeals Committee has upheld the denial. I've won one of those, and that's a case I probably shouldn't have won because it really didn't deserve that kind of adjudication from the committee, but it is not an objective evaluating board. It's a 5-member committee run by one person. The other 4 members sign the decision, but we all know they don't read it or listen to the evidence. So that's important. It's important to get safe harbor because to go through the gyrations of consistent with local needs is very, very difficult. Andy, if you could go to the next slide. The last bullet on this next slide is the most important. The board must require pro forma. The board has the right to require pro forma. The regulations do not say you can't require pro forma. The regulations do limit when you can require it, and that's why the regulations, your regulations, are so important to make sure that the pro forma is required and then vetted by an expert of your choice. Andy, the next slide is the 53G conversation. I think we've already had that, but that's going to be really important. Again, other than legal services, there's no limit on what the board can require in terms of expertise that you may need. And then, Andy, the next slide talks about the time frame. Remember, the 180 days is a firm number unless the applicant grants the board an extension, which they can, and you can accept it. And then the last 2 slides, Andy, are the decision itself. And I've got 6:47, Mr. Chairman. I can probably say this in just a couple minutes, and then I will stop. This is really important in terms of the board's long-term thinking about this. If the board denies the project, the burden of proof is on the city to show that the health and safety of the residents will be imperiled. Very difficult to sustain. If the board approves it with conditions, the appeal burden is initially on the developer to show that the project will be rendered uneconomic. That's a much better position for the board to be in. So the board generally wants to approve with conditions. Even if it's a very aggressive decision, that's a far better outcome than a denial. I'm defending a denial out of Weston right now that deserved to be denied, but generally speaking, denials are very, very risky. However, if at the same time the developer appeals your approval with conditions or denial to the Housing Appeals Committee, if an abutter, someone with standing, appeals your decision to Superior Court or the Land Court, their appeal gets automatically stayed, automatically frozen until the entirety of the Housing Appeals Committee and any appellate decision that follows is exhausted. And that's really, really important. So if your decision is appealed by both the developer and an abutter, the developer's appeal goes first, and it goes and goes and goes. HAC decisions 3, sometimes 4 years throughout the whole process. So that's something to consider strategically for the public, but also for the board, because now the board is really defending itself from a 40A17 appeal brought by an abutter, and you're also defending your case at the Housing Appeals Committee. Housing Appeals Committee decision goes first, and until that's exhausted, that gets stayed and remains stayed. So the time frames of all this become part of the board's deliberative strategy, all in an open meeting. There's no secrets here. You're discussing this, and you have every right to. And most of the time, if you have a good developer, this is a negotiable thing. Developer comes in at a large number, and they negotiate with the board if the board feels that this is a project worth negotiating. So let me stop there, Mr. Chairman, and thank you all for giving me the time.
Oh, thank you, Attorney Whitten. And we have time for maybe, 1 or 2 questions if anyone has any. I thought that was a great overview and very helpful for me to get started. I haven't had a lot of look other than being involved as a citizen in 40B issues, but I know we had a couple of board members that have been involved as you heard. So if there's anyone that has any questions, speak up now. Otherwise, we'll thank you very much. And I'm sure you will hear from the board as time proceeds.
Sure. Attorney Whitten, one question. I won't say it's a quick question, but it's a question. with regard to a hypothetical, maybe this isn't, you know what, I won't ask this question.
Withdrawn?
I'm not gonna ask the question. It's okay. Thank you.
Fair enough.
I have a question, Ken Swanton. I assume you've really highlighted the importance of having good regulations in place that the board, good policies in place that the zoning board of appeals would have. And you commented that ours are actually pretty good, but they're being worked on to make them better. I assume you're helping to work on that. You've now created a sense of urgency in me. When do you expect to have improved regulations in front of us to vote on?
So Andy and I have spoken. I've sent Andy a couple examples, and what my next conversation with Andy is really kind of the extremes that I provided. So I have sent Andy some very aggressive regulations, and I would say yours are somewhere in the middle. I can produce them as quickly as the board would like, working with Andy. So I can do it quite quickly, certainly before Christmas, and sooner rather than later if the board feels that that's not soon enough. I teach at Tufts. My teaching schedule is good until the second week of December, but I have time. I can do it.
Attorney Whitten, if I could just interject there as well, something that might be helpful, given that we can get the board's input here. My sense is, and I could be wrong, but I'll defer to the board. We are looking, the staff are looking at those drafts or those examples in comparison to our own, and we were going to circle back with you. My sense is, and I just wanted to confirm that with the board because I think we could expedite things on turnaround, is that the board would like, I would assume, a more aggressive, to the extent that it's feasible, aggressive regulations in terms of requirements, procedures, and so forth. And that we would effort in that and to return back to the board, a few weeks out with something that accomplishes that. So the further end of the spectrum. Could the board perhaps clarify if you're in agreement on that point?
I would agree with that. I assume everyone else would too.
Agreed, yeah.
Thank you. I think.
Okay.
Yeah, thank you, board members. And I think the reason, obviously, at least as a land use planning matter, is it's not that we don't want affordable housing, but we certainly, as a city, have designated where we want, multifamily housing or denser housing. And so I think, anything that's an exception to that should be taken, seriously and with, question before anything is approved. So I think that's the reason for having, a tight or aggressive, as Attorney Whitten says, set of regulations. So with that, obviously, Attorney Whitten and I would be circling back. We'll have some exchanges on the draft, and we'll come back to you with something we feel is in good order for you to consider for adoption or discussion further with us.
Okay. Thanks, Andy. And thanks, Attorney Whitten. And thank you, everybody, for the good questions and complicated subject that we'll get through together for sure.
Yeah, thank you all. Nice to meet you all. Look forward to seeing you again. Thank you. And thank you, Andy and Caitlin as well.
Thank you, Attorney Whitten.
Thank you.
All right, with the overview completed, we should we'll move on to the next item on the early agenda, which was our certificate of vote for electronic signatures. And Andy, I don't know if you had a little preamble to this. I wasn't sure how to best describe this.
Yeah, if I could, and I apologize, I am actually going to grab the screen for just a moment from Caitlin again. What I wanted to show was I did not, unfortunately, I wasn't able to turn around with KP Law. Attorney Whitten's been great on this 40B stuff. We have another attorney who works on some other issues, and he's strapped for time as well. But we didn't have a chance to circle back on the specific language for this certificate. Okay. But what I would ask is for the board to consider essentially the motion that I've just drafted this evening in light of the fact that I was then able to get something from KP for this meeting. But in essence, what we're trying to accomplish here, as noted on the agenda, is something that we similarly did with the planning board last year when the pandemic happened, where we specifically had the board vote and sign or authorize the chair to sign a certificate to essentially allow electronic signatures and for the board chair or vice chair, as the case may be, to sign on the board's behalf. And this is really just administrative task at that point, right? It's not really changing the board's vote in any way or, taking any authorities away. It's more just to deal with the ministerial act of signatures and whatnot. We're stuck with some cumbersome state statutes and regulations that haven't caught up. So in light of the, pandemic orders and the current statutes, what I want to do is the reason I could not provide you prior to this meeting a draft of that certificate is because the one for the ZBA would vary slightly from the one from the planning board just based on the applicable statutes. So I am conferring with KP Law on that before I provide that to you or to the chair. What I would ask is just to expedite that is, and I do think that the motion that I prepared here would suffice, is that you authorize the chair and or the acting or vice chair, in this case, Chair Moore, to sign on behalf of the board a certificate which confirms that the board, and would be the case here if you agree, hereby authorizes the chair and or the acting vice chair. And this is, I put this in there mainly because there may be instances in which there's benefit to doing this from an administrative perspective. The director of planning and development or the zoning administrator, as may be necessary, to sign for and act on behalf of the zoning board of appeals and to issue to use electronic signatures where applicable. Said certificate of vote to be written, just to be clear for all of you, reviewed and approved as to form by the city's legal counsel, that would be KP Law. And further, that said certificate of vote may be updated or amended from time to time, consistent with this vote in accordance with applicable law. I prepared this particular motion language, hoping you would agree to it, mainly because I'm trying to encapsulate all the potential varieties of what we're going to get back from KP Law on this. I want to confer with them on essentially a format that we have for the planning board that needs to be revised slightly. We're also trying to take into account the temporary orders that apply to the pandemic or have been extended, some rights for local boards to do things in a more efficient manner. We would hope the legislature would make things, carry those things into the law, but some of those things have been sort of kicked down the road from a procedural nature. So recognizing that, what I'm trying to accomplish here, if the board wants to vote tonight, is would allow us to expedite the electronic signatures that the registry, expect to have board approval for before the chair could sign. And that's something that the registry had requested. They did the same thing essentially for the planning board. And so we did that certificate accordingly. Again, if you're inclined, we'd ask you to approve this motion here, and then we would follow up with Chair Jim Petty and or more, depending on when we get that certificate back in the next week or two to have a certificate, and I can send out the one that we have for the planning board if you'd like for further elaboration, but it basically says and accomplishes what's in here. In the case of the planning board, for instance, I'm able to notarize or sign the approval not required plans that they get on their behalf. So once they've approved at their meeting or endorsed that A&R plan, I can then sign it for when it goes to the registry of deeds. That just saves the trouble of having to have a bunch of board members have to come into City Hall to sign those things. So it's really meant to be speeding up or making more efficient the administrative process outside of or after the board's vote relative to the substance of an application.
But you're asking the board tonight to authorize the motion that you just proposed?
That's correct. And if the board, and if the board wants to, continue the discussion on this and everything, that's totally fine. We're just trying to address this issue, and it's only because I was not able to get the language back from KP for tonight that I wanted to at least provide to the possibility of moving this piece forward. It's just one of those sort of, for lack of a better word, bureaucratic things we have to deal with, and we're just trying to make sure things are as efficient as possible.
Put everything we put together for the next meeting?
Yes, I would certainly expect to have that for you, for then. And I apologize not for tonight. It's just we're somewhat at the liberty of when we get turnaround from legal on things. So.
As a board, do we want to vote verbally, yay or nay, on this interim authorization ahead of seeing something in writing? Is there any discussion on that?
What's the risk of waiting till the next meeting?
It primarily comes down to more of just administrative hassle, just that, for instance, the chairs have had to come in and sign things, it's not, in my opinion, it's not a significant burden, but I don't think you're necessarily going to change a whole lot between now and then because the request would essentially be the same. The only difference is you'd see the format of the certificate. So again, I defer to you as a board, but I don't think it's going to change the substance of what's being requested here to deal with the administrative burden of once the board's voted on something, having that be something that can then be brought to the registry of deeds and accepted because they look for essentially to make sure that the board has either authorized or approved something. So,
I mean, given the lightness of tonight's agenda, given the continuous request, I don't have a problem if I have to come in until the next meeting, but if everyone feels more comfortable waiting for something in writing to see that before given the yay or nay, I'm fine with that if that's what the board wants to do. And if not, I'm also fine, moving forward. I don't see this as a big hurdle, but you always like to see things in writing first. So
yeah, I would agree with that, Mark. And if you're Mr. Chairman, if you're happy to to come in and sign anything during that, the period between now and the next meeting when we can
Yes.
see that.
I don't have a
would be-
problem. I don't have a problem doing that.
Okay, so in that case, I will follow up with KP, and we should all presume that we'll have that language for you for the next meeting to take a look at. And in the meantime, of course, or maybe simultaneously with that, I can send out what we did for the planning board, but it'll be somewhat comparable to the language within that one.
Excellent.
Great.
Thanks, Andy. Appreciate it. Okay, and with that, the clock has turned to 7. So 7 o'clock, normal start time for public hearings. For those just joining, we had a special early session tonight to review some 40B and some other board issues with respect to electronic signatures. We now start public hearings. We have established that we have a quorum tonight. Myself, members, Secretary Mr. Delisle, members Mr. Swanton and Mr. Chagnon. So we have 4. There's a minimum board this evening, meaning any application will need a unanimous decision of approval by the board to get the go-ahead and get the final approval on the application. So with the roll call already done, we have the quorum. I just re-explained that. Tonight, before we start the public hearings, we do have, I assume, in part due to the minimum board, we have some requests for continuances. We will address those first before going into the 2 remaining public hearings. But first, before we start these meetings, I always like to explain the format of the Zoning Board of Appeals Zoom format. With the roll call completed, we move now to public hearings. And I start by reading a description of the public notice to identify the application to be presented. I will then ask for the applicant to present the details and salient points of their application and proposed changes. Often, the applicant's legal counsel or the applicant's architect will present and describe the proposed changes to the property. Once the presentation is complete, we then proceed to one of the main reasons these are called public hearings. We will hear public comment. Although still virtual, public comment entails any resident that wishes to be heard electronically by using the raised hand button at the bottom of your screen. Andy Port, Caitlin Sullivan, or I will announce those that are recognized to speak. Please remember to unmute yourself and to give your name and address for the record before you begin to speak. Try to keep your comments succinct and to the point. We are on the clock with comments, but we rarely have to use them, but it definitely keeps the meeting moving more efficiently that way. While commenting, feel free to state questions you may have for the record, but allow the board to fulfill their role in eliciting additional detail in the questions from the board portion of the hearing. Public comments are not intended to be a Q&A directly between the attendees and the applicants. Thank you very much for your understanding. We will proceed with public comment until all raised hands are exhausted and those who wish to be heard are heard. Once public comments have been heard, that portion of the hearing is closed and we move on to questions from the board. The board, often inspired by the public comments and questions, will then ask the applicant or the applicant's reps for any additional detail needed in their decision-making process. When the board has exhausted their questioning, I will close that portion of the hearing and move on to deliberations, which in the public forum is another cornerstone of this public hearing format. Everything the board discusses about the application is done in public or virtual public here, so that all in attendance get to hear the thoughts and discussions of each member or the board as a whole as it moves towards a collective decision. During that process, it sometimes becomes evident that the board feels it needs more information or that the board is leaning in opposition for one reason or another. The board may then move to continue the application until it can obtain the desired information from the applicant, or if a denial of the application is looking like a possible outcome. The board often gives the applicant the opportunity to request a continuance to address the board's concerns at a future date in a future public hearing before deliberations close and the board proceeds with a formal vote. A formal vote to deny has consequences for the applicant with respect to timing and costs. Therefore, we would prefer that the application is fine-tuned and when possible versus outright being denied. Once deliberations are complete and no continuance has been sought by any party, I will then encourage a motion from the board. And when seconded, we'll call for a vote on the motion. Because we use a form of Robert's Rules of Order, you'll hear a motion on the application made in the affirmative or to approve, even if the board member making the motion plans to vote to deny. With a minimum of 4 votes, and tonight that's a universal 4 votes, in the affirmative, a motion or application that is approved. I will then close that application and move on to the next hearing on the agenda, applying the same rules. Once all the public hearings are complete, we close public hearings portion and move on to a business meeting, which includes approval of the minutes and any other items appropriate in that forum. We'll now proceed on to our public hearings tonight, starting with the 4 continuance requests, so that anyone that has just logged in won't be hanging around waiting to comment on a hearing that isn't going to happen. So first on the agenda tonight was application 2021-26 for 2 Neptune Street, Patty Ann Bampos, who has requested to continue until our 11/23 meeting. I don't know if Ms. Bampos is in attendance and has anything to say on this. Otherwise, we'll look for a motion from the members.
The applicant is not present, Chair.
Okay,
Hi, this is Ken Swanton. I move we continue the special permit for nonconformities for 2 Neptune Street, file number 2021-26 to November 23rd, 2021.
Bud Shagnon, I'll second it.
all right, we have motion made and seconded to continue the 2 Neptune to the 11/23 meeting. We now go to a vote. Mr. Delisle,
Yes.
Mr. Swanton,
Yes.
Mr. Chagnon.
Yes.
I am also a yes. Unanimous. This application is continued to 11/23/21. Next on the agenda would be for a 2224 Olive Street. That is a request for special permit nonconformities, and they have requested to continue also to the 11/23/21 meeting. I don't know if Attorney Mead is present. I'm sure she is and wishes to say something, or maybe she's not.
I am present, Mr. Chair.
Thank
Thank you. And as requested and due to the membership on the board tonight, we would like to continue to the 23rd, please.
Good.
Mr. Chair, this is Ken Swanton. I move we continue the special permit for nonconformities for 22-24 Olive Street, file number 2021-44 to November 23rd, 2021.
I'll second that, Stephen Delisle.
Right, we have motion made by Mr. Swanton, seconded by Mr. Delisle to continue this application to the November 23rd meeting. Now we'll vote. Mr. Delisle,
Yes.
Mr. Swanton,
Yes.
Mr. Chagnon.
Yes.
I'm also a yes. That's all in the affirmative. This application is continued to our 23rd meeting. Our next request for a continuance is the 4th item on the agenda tonight. It is Derek Lively or Jeff Scianti, 28 Liberty Street, Unit 5. That has they have requested a continuance to the 12/14 meeting. And I wonder if the applicant wishes to speak on that or just have the board vote.
The applicant does not appear to be present, Chair.
Okay,
I'll make a motion, Ken Swanton. I move to continue the variance application for 28 Liberty Street, Unit 5, file number 2021-57 to December 14th, 2021.
I'll second that, Stephen Delisle.
all right, we have a motion made by Mr. Swanton. I'm going to go seconded by Mr. Delisle and then go to a vote. Got to be quicker. Mr. Delisle,
Yes.
Mr. Swanton,
Yes.
Mr. Chagnon.
Yes.
I'm also yes. All in the affirmative. This application is continued to the meeting of December 14th. And finally, the last item on our agenda, and is also the last item for continuance, is for 4 Plum Street. Mike Buchan or Anna Wallach, care of Lisa Mead, request a continuance to the December 14th meeting. Attorney Mead, I assume you just wished for the board to vote on that.
I do. And the reason for this one, though, is that we're not out of historic yet. So
Got it. Okay.
there we go to December 14th, please.
Thank you.
Okay, I'll make the motion again, Ken Swanton, to continue the special permit for nonconformities for 4 Plum Street, file number 2021-59 to December 14th, 2021.
Bud Shagnon, I'll second it.
There you go. We're in. Motion made by Mr. Swanton, second by Mr. Chagnon to continue this hearing to 12/14/21. And now we'll vote. Mr. Delisle,
Yes.
Mr. Swanton,
Yes.
Mr. Chagnon.
Yes.
I am also a yes. All yes. This application is continued to our December 14th meeting. So that concludes the quick and easy part of this on the continuances. And we move now to the two items left to discuss tonight. The first application is 50 Boardman Street, application 2021-56, special permit for nonconformities to remove an existing accessory structure / garage and construct a new one in its place. Bruce Atkins and Gail Casson, care of Lisa Mead, Tellerman and Costa. Might we hear from the applicant?
Thank you, Mr. Chair and members of the board this evening. On behalf, Lisa Mead, Tellerman Costa, 30 Green Street, on behalf of Bruce Atkins and Gail Casson, who are the owners of 50 Boardman Street. Next slide, please. So the applicants are requesting a special permit to remove an existing garage shed. It's small, very small garage, but bigger than a shed, and replace it on the same footprint with one that is slightly taller. The property is located in the R2 zoning district in the DCOD, and the property is improved with a single family home and this building. No work is proposed on the single family home. The accessory structure is not listed on the district data sheets, but does appear on the 1924 assessor's map, but not on the 1914 Sanborn map. Not being able to exactly pinpoint the age of the structure, and since it's an accessory structure, it would be subject to demolition delay if it were 100 years old. We went to the Historic Commission nonetheless. The Historic Commission made a determination that the structure was not historically significant and therefore did not impose a delay. So here we are for the special permit for nonconformities to now rebuild the structure. So in the R2 district, the zoning requires a 10,000 square foot lot. The property is 2,803 square feet and includes 108.50 feet of frontage where 90 are required. This lot, as you'll see shortly, is on the corner of Boardman and Washington Street and therefore enjoys the frontage from both streets. The structure, accessory structure is located 0.7 feet off the rear property line, which is opposite Boardman Street, and 1.2 feet off of the side property line, which would be as you face it on Boardman Street to the left. The existing structure is 13 feet to the peak and has a mean height of 10.6 feet. If you can go to the next slide, please. The new structure we propose has a on the same footprint, is slightly taller at 16.6 to the ridge and 13.6 to the mean, which is an increase of 3.6 feet. So if you could go to the next slide, please. So as you can see, here we are at the corner of Washington and Boardman Street. And if you look at the lot, in the back left corner of the lot is the structure. So it sits tucked back into the back corner. So as you're going to see shortly in some photographs we have, is not really visible from Washington Street until you get right on top of it and is pretty much blocked out from Boardman Street. So the idea is that it will be in that exact same footprint, but be slightly taller. Next slide, please. And here's a sketch of the existing conditions. I didn't note for the board, but Bill Supkoff, who you're a little bit familiar with, is the architect on this project. So here are the existing conditions. The only thing that's a problem with these conditions is that they're actually shown to be square, and the the actual structure itself leans quite a bit. So in any event, these are the existing conditions. Next slide, please. And here's the proposed conditions. So you can see the footprint and then the front elevation and the side elevation. I will note that the structure will be finished to match the existing structure, house structure, and will be finished with clear cedar clapboards and appropriate windows, as you can see, is shown on the plans. Next slide, please. So here we're going down Washington Street to the west, and you can see the structure in the back. Next slide, please. And here's a head-on from the structure located at the back of the property. Next slide, please. And a few years ago, this is what the structure looked like. Originally, actually, the zoning board, and this is an old photograph because about 10 years ago, the then zoning board gave permission to tear down the structure and build a larger structure in footprint. And that's what this outline is. But that variance, which was required at the time, was never exercised. And so we're back for a special permit for nonconformities. But you can see the problems with this structure. For the Historic Commission, we showed a number of photos of the inside of the building, which aren't necessarily relevant here. But just so you know, the building is actually being held up by ropes on the inside, stretching from one side to the other. In the next slide, please. And then Bruce and Gail have actually tried to straighten it out a little bit with those ropes on the inside and to put some kind of outside painting and whatnot on it to spruce it up while they've been going through this process. Next slide, please. So the criteria for the special permit for nonconformities is that there will be no new or additional nonconformity, and here there aren't any. There is an intensification of the side and rear setback because we're going a little higher, but there are no new nonconformities. The footprint is exactly the same. And then, of course, is that whether or not the proposed change will be substantially more detrimental to the neighborhood than the pre-existing non-conforming structure. Here, there's no change to the footprint, so there'll be no change to the open space or lot coverage on the lot. As we've shown, the architectural style of the new garage or shed is appropriate for the location and consistent with the house which exists on the lot. The exterior of the structure, while it may look good, as I noted earlier, is actually in really tough shape. And is unsound and actually not really usable. The architect has warned against actually going into the building. The home is on the property, actually fronts on Boardman Street, and so this structure is actually tucked in the back corner, as you could see. The proposed structure, as I noted, is going to be finished with clear cedar clapboards and will match the architecture of the home. And the design is simple but appropriate for the property. The proposed structure is actually 42 feet from Washington Street and therefore far away from the sidewalk. And so with that, we think the board can find that certainly the proposed height increase and renovation or removal of this structure and building of a new one is not substantially more detrimental to the neighborhood than the existing structure. And we'd request you make that finding. Thank you very much.
Thank you very much, Attorney Mead. We'll now turn to comments. If there's anyone in attendance to me that would like to be heard on this application, please click the raised hand icon on your screen and wait to be introduced, and remember to reintroduce yourself with your address before you speak and after you've unmuted. Is there anyone that wishes to participate in public comment?
I'm not seeing any hands at this time, Chair.
Not seeing any hands. Let's give it going once, going twice. Gone. I will now close the public comment section and move on to questions from the board. And we'll start, as always, with Mr. Delisle.
Thank you, Mr. Moore. I don't have any questions on this one. Seems pretty straightforward to me. So I will pass and yield my time. Thanks.
Excellent. Thank you, Mr. Delisle. Mr. Swanton?
Yeah. Could you put the site plan back up? I could you blow it up a little bit there? So I understand this is 42 feet from Washington Street, the front of this building. Is that correct?
Yes, sir. Yes,
I
sir.
see. Yeah, and the parking's in front of it. Yeah. Have there been any abutters chime in positively or negatively? Obviously, nobody spoke during the public comment period, but are there any letters in the file or any comments either for or against?
No, Mr. Swanton, and not to my knowledge. I mean, Caitlin can obviously answer that, and nobody showed up at the Historic Commission meeting either.
Okay. Actually, I have no questions. Thank you.
Thank you, Mr. Swanton. Mr. Chagnon?
Just one, it's probably just a clarification. I think you stated this, Attorney Mead, but the the actual footprint's the same, so the width of the garage is the same as the old garage. The only change is the vertical height.
That's correct.
Okay, thank you.
Thank you, Mr. Chagnon. I don't have any further questions from anything that's been asked. It was pretty straightforward as well and presented well. So with that, we'll close unless someone wants to reevaluate with another question. We'll close questions from the board and move on to deliberations, starting with Mr. Delisle.
Thank you, Mr. Moore.
Remembering, just to be interrupted, as we always have to couch our deliberations with respect to special permit in this case.
Thank you. Yeah, so I can support this project. I think that under the cited section in the memo of 9B2A, that there will be no new nonconformity here, and the change requested will not be any more detrimental to the neighborhood than what was currently there. So I think that fits both criteria. I have no problems with this and can fully support this.
Thank you, Mr. Delisle. Mr. Swanton?
Yeah, I think Mr. Delisle well cited the regulation. I mean, my bottom line here is it's on the same footprint as Bud asked about. It's only 3 feet taller. It's 42 feet back from the street. I don't see how this is more detrimental. So I can support this.
Thank you, sir. Mr. Chagnon?
I couldn't say it any better than the previous two colleagues, and I can support this application.
Thank you, sir. And I would agree with Mr. Chagnon as well. So I could support this. So at this point, I will close deliberations and look for a motion.
I'll make a motion to approve the special permit for nonconformities for 50 Boardman Street, file number 2021-56.
I'll second it, Ken Swanton.
Motion to approve made by Mr. Delisle, seconded by Mr. Swanton. We now go to a vote. Mr. Delisle?
Yes.
Mr. Swanton?
Yes.
Mr. Chagnon?
Yes,
I am also a yes. As necessary, all in the affirmative. Application is approved.
Thank you very much for your time this evening.
Thank you. With that, we move on to the last public hearing of the evening. Might be a record saying that, 7:22. Given our track record over this pandemic Zoom meeting thing, but I'm making it longer by yammering on, so I'll stop. The last public hearing is application number 2021-58, a sign variance to install a wall-mounted sign exceeding the allowable size at 20 Henry Graff Jr. Road. The applicant, All About Signs LLC, or Jim Withrow. And right now, we'd like to hear from the applicant.
Good evening, board. Thank you for having me. I'm hoping you grant us some relief on the size of the sign. That's because on this building, the square footage allowed would look like a postage stamp on this building. What you see is to scale. So I hope you, and we made it so it's not illuminated. So it's just, there's going to be cut painted letters, stud mounted onto the building, and no illumination. It's just for patients to be able to locate this building. As to date, they had over 50 people that cannot find the building because all I have is a monument sign out front, but even that's set back. And this building is set so far back off the road, something's needed on the building. And if I was only allowed to put the smaller letters, it would look, like I said, like a postage stamp. That's 40 feet in the air, and that's the scale. So I hope you agree that I'm not asking for a lot. It's proportionate to the building, I think, but you are the expert. I hope you grant us relief.
Okay. Is there anything else you'd like to present to the board with respect to, you mentioned And with respect to anything to do with a variance that the board would need to consider in granting this.
Well, I did take pictures from the road, one from one side of the road. That's right. And this is the monument sign right here on the left. And that's all they have. And if you know the road, there's, I call them cat nine tails, but you know, it's marsh all along the road. So you have to be right on top of this and look right or left or whichever way you're going to see it. And I worked there many days and I drove past it. and so impatients are having a hard time. So, and you can see how far back it's set. The building is just so far back there. So yeah, I have another slide that's from the other side of the building of the road. That's even, yeah, it's just, that's they have to know what that is. And it's been difficult for patients to locate this building. So I'm hoping you'll grant relief on the size of the sign allowed.
Okay. All right, thank you, Mr. Withrow. I think if you have nothing else, and we'll close the presentation and move on to look for public comment on the application. So again, if anyone is in attendance that has something to say, please use the raised hand icon and wait to be recognized and state your name and address before speaking. And of course, after you've unmuted. Does anyone wish to comment?
Not seeing any hands at this time, Chair.
Thank you, Caitlin. I'll give it a going once, going twice. And gone. We're closing public comment, and we'll move on to questions from the board, and we'll start with Mr. Delisle.
Thank you, Mr. Moore. Mr. Withrow, is
Yes,
the issue here is that the location of the building set back on the property far from the road is it makes it very difficult to see the sign if it were to be what was in the regulation. It's no more than 40 square feet.
correct.
And this one is almost 102 square feet is being proposed.
Yes, sir.
So the sign that would say Sports Medicine North, if it were 40 feet, it would be
Say the size of the word medicine, I would say.
Yeah, okay. I thought maybe Medicine North, but like half as tall or something like that. But anyway, yeah, so, okay. So it is the fact that you're so far back, and then you indicated the cat o' nine tails obscure the monument sign. Is that right?
They do, but we had to. That's where it was on the plan, so that's where I had to put it. I couldn't put it any closer to the road.
Okay, but the location of the building on the lot makes it difficult to see the sign on the building from the road if it's not the requested 102 square feet or nearly 102 square feet.
Correct.
That's right.
It's very difficult. Yes.
Okay. I don't think I have any further questions. Thanks.
Thanks, Mr. Delisle. Mr. Swanton?
You know, and driving down the road, I see other buildings with big signs. I mean, we don't see a lot of sign proposals in front of us. Mr. Delisle already kind of probed kind of what I was going to ask. So I guess I'll pass. No questions.
Thank you, Mr. Swanton. Mr. Chagnon?
Yeah, it's probably, again, just a clarification, but in looking at your drawing that's here in front of us, 276 inches long, so the sign's 23 feet long. It basically spans those three windows on the right side. But the main letters are only 20 inches tall. So I found that to be quite modest. I know it's almost 3 times the size of our ordinance, but I guess I agree with the applicant. A 40 square foot sign would be pretty much lost on that building. So I guess I don't really have any questions other than I've convinced myself that it's an appropriate request. Thank you.
Thank you.
Thank you, Mr. Chagnon. My only question is to get back to the placement of the building with cat and nine tails around the front and around the roadside. Is the location of the building there because of the wetlands and to get, because it had to be because the topography of that lot had to be such as to place that building so far away? Do you know that to be a fact?
I do not know that.
Okay. Okay, and I think my colleagues have asked all the other questions that I would ask. So, and with that, I'll close questions from the board and we will go to deliberations. Remember what our findings need to be for a variance in this case when we discuss where we're headed with this. So I'll start with Mr. Delisle.
Thank you, Mr. Moore. I think that as we've sort of discussed kind of through the question and answer period here on Graff Road, it is, we can see that all the buildings are set back, and it is likely due to the fact that there are drainage trenches and wetlands that line the road. So, given that the lot and those conditions perhaps require the building to be where it is located, the signage regulation would make it difficult for patients to see the sign and perhaps drive by the building. So I don't think that this is a outsized ask for what is present on Graff Road and present with some of the other signage, especially of other medical facilities in town. So I think that we can satisfy the criteria of the variance standard under XH 6C. I think you have the conditions and circumstances are unique with respect to the lot and the location of the structure due to the as you noted, Mr. Moore, the topography and the wetlands in one side of the property. So I think that allows us to really find that a variance here for the signage is appropriate without the grant of a special privilege. So I can support this.
Okay, thank you, Mr. Delisle. Mr. Swanton?
I concur with Mr. Delisle.
Excellent. Mr. Chagnon?
Total agreement. I can support this. Thank you.
Thank you. And yes, and I'm in agreement with my colleagues. I don't think it's unreasonable or an unreasonable ask, as I think Mr. Chagnon said, to have a larger sign given the location of the building, its orientation there, the fact that the road obscures a lot of what you can see, so you really don't get to see it until you're on top of it. And if you're going to see it as approaching it, you need to have a little bigger signage to know what you're looking at and before you passed it. So I don't see it being an unreasonable request at all, and I can support this. So with that, I close deliberations and we'll look for a motion.
This is Mr. Shagnon. I'll draft a motion to approve the variance for application 20 Graff Road Junior. 20 Henry Graff Jr. Road, file number 2021-58.
I'll second that, Mr. Delisle.
All right, motion to approve made by Mr. Shagnon, seconded by Mr. Delisle. Go to a vote. Mr. Delisle?
Yes.
Mr. Swanton?
Yes.
Mr. Shagnon?
Yes.
I am also a yes. That's all in the affirmative as is needed tonight, and therefore the application is approved.
Thank you so much.
You're welcome. With with that, we conclude our public hearings for the evening, given the plethora of continuances. And we now move on to the business meeting, which will consist of two things. First, the approval of the minutes from our 10/26 meeting. Does anyone have any additions, subtractions, corrections, notations? None?
I have one little thing on the minutes.
Yep.
On the Curzon, on the first page on 65 Curzon Mill Road, the first line, the applicant is requesting a variance to extend an existing two-story garage with and construct. The with and is, you gotta lose one of those two words, I think. I don't almost care which one disappears, but one of those words should go. It's either the garage, I guess the with goes, a garage and construct additional living space above it. So I propose we delete the word with. Other than that, I have no other changes.
Excellent. I did notice on that application, and I don't know if this is a technicality or should be noted, that I did recuse myself. I wasn't reflected in the voting on the continuance, but I don't think it was ever noted that I recused myself from that. So if that needs to be put in, I would suggest it's done. I'm not sure it needs to be there. And with that, I don't have any further changes.
I propose with those two changes, we approve the minutes.
Second that.
All right, motion to approve the minutes made by Mr. Swanton and seconded by Mr. Delisle. We'll go to a vote. Mr. Delisle,
Yes.
Mr. Swanton,
Yes.
Mr. Shagnon.
Yes.
I am a yes. As amended, the notes from the 10/26 meeting are approved. Last but certainly not least, we have an update from, we'll have an update from Mr. Andy Port to close out the meeting. Andy, do you want to jump in and?
Yeah, thank you, Chair Moore. If I could, I'm just going to grab the screen from Caitlin for just a moment. I wanted to point to two things that I thought might be helpful for the board members. One is short-term rental units. This board doesn't typically comment on zoning changes per se. The planning board is required to do so under state statute and local zoning before the council adopts zoning. But some of you might be aware that the city council has been talking about for the last year and a half, maybe at least, the possibility of adding a regulation for short-term rental units, what we refer to locally as Airbnbs. At any rate, there are two ordinances that have been circulating amongst the council for about a year and a half now in various different formats. One is for zoning, the other is for licensing of those operations. And there's various different parameters. I'm not going to go into all the minutia of that for you now. But we do have drafts of that as they were provided to us. They are posted on the city's website, and Caitlin and I can forward you the links. But what I wanted to point you to, at least as sort of a heads up, and I can follow this with an email tomorrow, is the clerk's office had posted the recording of a council meeting that was held last week on Wednesday, November 3rd at 6 p.m., at which point they were discussing the possibility of shifting from a licensing procedure to a zoning, a special permit, essentially, that would be issued by the ZBA. And so because that may come with, that has another role there for the ZBA that wasn't originally in part of this package or discussion. And that could also have an influx of workload for the ZBA in terms of also a substantial number of applications coming in at once based on the number of short-term rental units in the city, the need for permitting and so forth. We just wanted to flag that for you as something you may want to take a look at, and to the extent you want to provide any concerns to Caitlin and I, or attend or weigh in on any future council discussions, meetings that they would post, and we'd have to defer to their schedule. We just wanted to identify that to you as something that might be an additional area of permitting oversight that you would have if something like this is adopted as a special permit process as opposed to licensing. So we just wanted to make sure that, one, you could follow that, and two, weigh in on it if you had any concerns one way or the other on that. We've been monitoring and weighing in, in terms of the process, the particulars, but the council has to decide what parameters to set. We just want to make sure that there's enough administrative capacity to handle the influx that might be coming in. And obviously, from the board's perspective here, you might have maybe more nights of hearings or a flux, at one time a year in which there's a ton of applications coming in for the same, special permit. So just something to think about. If you have any questions or concerns, you can certainly relay those through Caitlin and I, but we're just trying to coordinate with the council whether or not that is something that's adopted in the coming weeks or months. I don't know if there's any questions on that particular point, but we just wanted to direct you. I'll send you the link to this meeting tomorrow. We can forward you the drafts that we're aware of, and those are, I guess, continually evolving as the council is considering changes to them. But we just wanted to let you know that it looks like it's been a shift of course to possibly the expectation that the ZBA reviews special permits for those uses in the city, where there's several hundred versus licensing through the licensing commission.
Just a quick question, Andy, Ken Swanton, is that a one-shot deal, like, or people have to?
Yeah, that's a great question. Yeah, that's an excellent question, Ken. And I'm sorry I didn't elaborate on that. The general essence of it is that that's a good point, that there would be a one-time application for the applicant on a particular premises. You could assign that to the particular owner as opposed to running with the property. However, so that there's an argument to be made that that's a one-time, situation for that particular owner or operator at that property. But it would be, it's a little bit more process, I would say, than a licensing process, obviously. And on the flip side, if it was a license, the license would be issued on a yearly basis, or could be adjusted to a 2-year, but on a regular basis by the licensing commission. So while the process would be done once, the process would also be much heavier, I would say, through the zoning than it would be through the licensing procedure. But to your point there, it could be done as a one-time thing for the property, or one time for the property, the operator itself, thereby requiring if someone comes into that property, to come back to the board for a permit of their own. I don't know if that answers your question.
No, you did. Thank you.
I don't know if there's any other questions on that particular issue. I just wanted to bring that to your attention. The other one was, as I mentioned earlier tonight, there is a working with 40B overview by CPTC, and some of you board members have been here for long enough. You've seen me send an email or two about if you're interested in attending one of these sessions. What you have to do essentially these days is register yourself and then send us the confirmation email. That would go to Diane in our office. And she would handle the payment. A check would be sent in collectively for everybody, is the way that it works now. But I'll send you the link to this tomorrow, of course. But if you want to go to this session on December 21st, it's a Zoom or online session they'd send you the link to. It's December 21st. It's a Tuesday, 5:30 p.m. They usually run about 2 hours. And you could attend that. We pay the cost for it, and you could attend that as well if you feel that overview might be helpful. I certainly recommend it to anybody who has the time or ability to do it. So just wanted to extend that as well.
Is that the same session you recommend? I mean, I went to the one in June. Is this the same one being rerun?
Yeah, this is in essence the same session. There might be slightly different, comments that are made or secondary comments, but it is in fact the same sort of overview. Yes.
It was pretty good, actually, if you haven't seen it. So.
Yeah, I do recommend it's always helpful to have members attend these. They do other sessions as well, like boards, rules and regs, and how to review special permits and variances and whatnot. And we're happy to sign you up for other ones as well that might be applicable. I'll send you a link to the page, and you can advise if there's others you'd like to attend. We obviously, in addition to our assistance to the board, we recommend board members get some more background. It's similar to what the Conservation Commission does through the MACC, or Massachusetts Association of Conservation Commissions.
Good. Thanks for the info, Andy, and thanks for the vote of approval, Ken, on the presentation, because sometimes you do these things and scratch your head afterwards. So I'm glad to hear it was very helpful.
Yeah, it's better than some.
Good. It's good to hear. All right. I believe that's it. Andy, is it on your updates for this evening?
Yeah, unless there's any questions about anything. Thank you.
Questions, anyone? If not, I would say we've covered everything on the agenda this evening, and there's only one thing left to do.
I move we're done, whatever the word is. We're finished.
Adjourned.
That's it. Adjourn.
Motion to adjourn by Mr. Swanton, seconded by
I'll second that.
Mr. Delisle. We'll just do a voice vote. All in favor, say aye. Aye.
Aye.
Opposed? Nay. Excellent. Meeting's adjourned. Thank you, gentlemen. Thanks, Caitlin. Thanks, Andy.
Good night, everyone.
Thanks, everyone. Good night.
Have a good night.
Good night.
Bye.
Bye.